We'll go on to our second case, and after the second case, we'll take a 10-minute break. Our second case is Cherry Bomb Electric, Inc. versus Tomahawk Drive Associates, etc. Case 18-3799.
May it please the court. Good morning. My name is Adam Bird. I represent the appellant in this matter, Cherry Bomb Electric. Cherry Bomb's principal, Mr. Woody Cherry, is here with me today in the gallery. We're here today because there are two overarching issues that the trial court got wrong that led to an erroneous result, in fact, the opposite result of what the evidence and what the law compels. We have, I believe, 6 or 7 issues in our initial brief, but there are two overarching issues that I think are the most obvious that require reversal, not just for a new trial potentially, but for judgment in favor of my client. The first is that the trial court, in summary judgment, in granting a fraudulent lien summary judgment, and at trial, applied the wrong legal analysis and standard to the fraudulent lien statute and legal tenets set out in 713.31. As the court is likely aware, that requires willful exaggeration of construction liens or gross negligence in the compiling of construction liens that arises to willful exaggeration. And we set out in our initial brief the Black's Law Dictionary definition of willful exaggeration. Willful itself requires more than just voluntary or even intentional conduct. It requires evil, malice, bad faith.
But it can also be grossly negligent under the statute, correct?
The statute, Your Honor, says gross negligence amounting to willful exaggeration. It has to rise to that standard. So in my opinion, that statute requires more than just gross negligence because it has to meet that extra standard of willfulness, almost intentional gross negligence, if you will.
I mean, one of the things that concerned me here was it seemed the lien amounts were equal to the contract price. Is that correct?
No, sir, they were not. One of them was. I believe that was the Building E contract, which we ultimately dismissed after recalculating in response to second interrogatories.
6 years after the lien was filed.
Yes, sir. And the reason that it took...
I mean, to me, you know, there's like a 90-day window you can come back in and make corrections, right?
Yes, sir.
And within that 90-day window, Cherry Bomb's attorney sent him a letter, I believe it was within the 90 days, in fact, I'm sure it was, saying, wait a minute, you're saying you didn't get any payments at all? And Cherry Bomb doesn't respond to him. Ultimately, they part ways. But, I mean, when your counsel asks you, you tell him you didn't get any payments, you don't correct that until 6 years later. Somehow that suggests to me more than just a good faith error or a little miscalculation. So maybe talk to me about that, please.
Yeah, happy to, Your Honor. Mr. Kinberg's letter, that's the board-certified construction attorney to which my client went, he testified in deposition, he testified at trial. And number one, I can't explain why he took the position that Mr. Cherry and Cherry Bomb had supplied evidence that there had been no payment. His own liens belie that specific content of his letter because he included payments. He calculated payments. Mr. Kinberg was asked at trial in August of 2018, sir, your calculations, you've seen how we've recalculated. You've seen our answers to second interrogatories where we've said that there was a misapplication of payment and that these lien amounts had to be reduced. And that, oh, by the way, you included a lien amount for a full contract price on Building E, $2,000 of what were ultimately around $18,000 worth of liens.
Right, but in the trial transcript, Mr. Cherry, and I'm looking at page 209 of the transcript and a little bit after that, there was a discussion of the $2,000 being misapplied. And again, you know, that is an accounting error, should have been discovered earlier maybe, but put that aside. You know, you could see how that $2,000 may have been an honest mistake, a calculation mistake, whatever you want to call it, an accounting error. But that's $2,000, doesn't explain why there's $4,500 in difference. It explains $2,000, but it leaves the other $2,500 unexplained. And Mr. Cherry said, I'm not for 1 minute trying to reconcile that. And again, if you're talking about gross negligence amounting to willfulness, if you don't care how the figures got there and you don't know what they are, and you don't check it until 6 years later because it's not that big a deal to you at the time, how can that not be gross negligence amounting to willfulness?
Precisely because Mr. Cherry admitted at the time that the liens were created and compiled by Mr. Kinberg's office that he didn't exactly know what to do, which is why he went to a board-certified construction attorney to compile the liens himself. And Mr. Kinberg testified at some length about the procedure that he follows when he does that. The documents that my office ultimately used with Mr. Cherry's assistance to prepare the answers to second interrogatories were the same documents that Mr. Kinberg's office has. Mr. Kinberg could not explain why my office came up with a different calculation. What he did testify about in both his deposition and at trial was that he still believed, in the face of our answers to second interrogatories, that his calculations were correct. Even in the face of the payments, even in the face of everything that Mr. Cherry testified to before Mr. Kinberg testified, Mr. Kinberg still stood by his calculations. If Mr. Kinberg stood by his calculations 8 years later in the face of our evidence, why is it wrong for Mr. Cherry to have stood by his calculations 2 years or 1 year or 30 days after the liens were prepared? Mr. Cherry and my office relied on Mr. Kinberg's calculations using precisely the same documents. So while Mr. Cherry...
But when asked in the letter, and I think the sequence was, the liens are filed, Tomahawk sends its letter, which I think later becomes maybe Exhibit 18, saying, wait a minute, here's what our records show. Then Kinberg sends a letter to Mr. Cherry going, well, wait a minute, you said you didn't get any payment. We need to get this all sorted out. And doesn't get any further information from Mr. Cherry. I mean, correct me if I'm wrong, but I think that's the sequence, and that's kind of where it ended. And, you know, if indeed Mr. Cherry Bomb had gotten payments, you would think they'd go, oops, our bad. And again, you know, he's an electrician, he's not an accountant. I messed up, I didn't tell you, here's the rest of the facts, you're still in the 90-day window, you can clear it up. I mean, that's troubling to me.
I understand, Your Honor. Mr. Cherry had supplied Mr. Kinberg with everything that he had. He had nothing left to give him. Mr. Cherry supplied his invoices reflecting payment. He supplied his invoices reflecting work. The issue with the misapplied payment was not that the payment was never applied. It was applied, it was backed out, and then reapplied elsewhere, and the backing out of Building E basically it changed the analysis because it took Building E, which was a $2,000 contract, and said, okay, no payments were ever made on Building E. So Mr. Cherry didn't have any additional information. Additionally, Mr. Kinberg testified that he would not have recorded the liens if he did not have all of the information that he needed. And there's a slight discrepancy in the factual background. The letter with Exhibit 18 actually came within a few days after August 20th, 2010, when the relationship ended. I believe it actually came before the liens were recorded, which was in September 29th of 2010. The letter from Mr. Kinberg was actually sent the same day that the liens were recorded. And Mr. Kinberg was specifically asked, sir, you're a board-certified construction attorney. Would you have recorded claims of lien if you didn't have sufficient information on payment and amounts from the contractor to be confident that what you were recording, not just preparing, not drafting, but recording, were accurate? No, I would not. He believed they were accurate, and I keep coming back to, he said in August of 2018 that his calculations, even having never received anything in response from Mr. Cherry to his September 29th, 2010 letter, were still accurate. He never changed his tune.
So we're here on an abuse of discretion, on at least the liens that were disposed of by way of the final judgment. An abuse of discretion standard, you agree on whether the trial court's determination was correct in terms of finding a fraudulent lien?
I believe it's a de novo review for the issue, for most of our issues, as a matter of fact. The finding of fraudulent, I'm not asking the court to reweigh the evidence, but the legal standard that was applied, and that's why it's a de novo review, is because the wrong legal standard was applied. It's a strictly legal issue. The case law, all of the cases cited by Cherry Bomb, all of the cases cited by the appellee, identify the things that the trial court must consider when determining the existence of a fraudulent lien. 713.31, the legislature has said, it even says, it has legislative intent within the statute itself. It's designed to prevent lieners from including work they didn't do. It's not designed to punish lieners for good faith disputes over amounts due. And this was an amounts due case. But beyond that, looking at the case law that exists, what in the annals of Florida history, what's been determined to be a fraudulent lien under 713? Recognizing that the current version of the statute was from 2007 moving forward. It's inclusion of amounts for work that you didn't do, and moreover, that you knew you didn't do.
And I think that's what the trial court was honing in on, because when you look at the order, there seemed to be an emphasis on the fact that when that initial demand was made, it was made for $17,000. Then when you go through the process of coming up with calculations for the claim of liens, that totals at $22,000. And so my view of the trial court's order, and tell me if I'm mistaken on this, is that discrepancy between the $17,000 demand and the $22,000 that was ultimately claimed, there was a willful ignorance, so to speak, of why that discrepancy was. And that seems to be what the trial court focused on, and that would have been consistent with the cases saying that we knew the contract price was $55,000 and we claimed 70 or whatever it was in those cases. So why is that kind of finding on willful ignorance between those two numbers, one, subject to de novo review, and two, inconsistent with the evidence?
I think the answer to the second part of the question is the amount was the issue for the court. And if you read the summary judgment and you read the final judgment, there is no finding of the words willful, exaggeration, or negligence do not appear in the final judgment. So I think that interpretation potentially adds analysis that doesn't exist. What the final judgment says time and time again is that the liens are overstated and therefore that they're fraudulent. There is no causal link between the two in the judgment. There's no explanation of what the overstatement means. We've cited cases in our initial brief. Overstatement in and of itself does not render a lien fraudulent. It is but one factor for the court to consider, like advice of counsel, like inclusion of work. And the issue is, and even under abuse of discretion standard, there was no evidence that there was work included in the claims of lien that was never completed. And that was asked of both of the witnesses that were called by Tomahawk at the trial.
Those claims were made in the contract content, though, weren't they? For each count on breach of contract, your client claimed that it had performed all required of it.
Up to the date of termination, correct. There was no allegation, and it was...
It had performed all its obligations and was suing because it hadn't been paid all the money it was owed.
I believe Cherrybaum sued for the work that was completed. I don't believe that our claims included all of the work under all of the...
Despite the fact that CBE performed all of its obligations under the first contract, Tomahawk breached by failing to pay CBE all sums due. That's paragraph 12.
Yes, sir.
Paragraph 21, despite the fact that CBE performed all of its obligations under the second contract, Tomahawk refused to pay, so on, so on, so on. So in the breach of contract counts, Cherrybaum's claiming it performed everything. You look in the affidavit from owner, it looks like he's claiming he performed all of his obligations. So, I mean, when you take that and you take what Judge Sasso was talking about, you've got the $17,000 we say you owe us, but we're liening you for $22,000. It doesn't seem just to be a math error. It seems to be more than that, and that's what the trial judge found. And how do we reweigh all that evidence?
Well, respectfully disagree, Your Honor, that the trial judge found that there was an intentional exaggeration. There's simply no evidence that the trial judge ever found that, either on summary judgment or in the final judgment. In fact,
You're required to state that specifically?
Yes.
By what, not by the statute?
No, sir. The cases that we cited that identify that, excuse me.
That's Rogers Properties?
Yes.
Which says the court needs to make that there was no finding, there was no competent substantial evidence actually of that.
It indicates that there's a requirement that there be a finding of willful exaggeration.
But not an inclusion of that finding in the final judgment necessarily.
how else are we to know that the trial judge made such a finding if not included within the final judgment? That's one of the reasons that we've stated that there's an error here, a glaring error.
And was that raised in rehearing that the form of the final judgment was deficient?
Do not believe so.
Okay. Does that impede our review?
No, ma'am.
And why not? Why isn't that something that needs to be preserved?
Because it's the judgment is inherently flawed. In other words, I'm not going to ask, I can't ask the trial judge to reweigh and reevaluate the evidence and change what's been found. Her findings were you overstated, the liens are overstated, and therefore that they're fraudulent, which was also in keeping with what the trial judge found on summary judgment. So I suppose it could have been raised on rehearing. I don't think that necessarily prohibits the court here from making a decision that the judgment just doesn't go far enough. And I think if you look at the other language within the judgment that specifically says, well, at best, this was poor record keeping, again, not the standard for fraudulent lien, and at worst, an invoice or the invoices were prepared in anticipation of this litigation. What does that mean? That is not a legal standard. That is not even a finding because it's saying, well, it falls somewhere on this spectrum. But that's not the standard for finding of a fraudulent lien, and that's the overarching issue. And the second issue was the finding that the trial court made that Cherry Bomb breached first, because I think who breached first in this case is determinative of the outcome. And the undisputed
You're into
evidence-
your rebuttal time. You can use it as you wish. I mean, you can keep going if you want to.
I'll reserve my time. Thank you very much.
May it please the court. Good morning, your honors. My name's Jennifer Peterson, and I represent TOMAHAWK Drive Associates. Your honors, we're asking you today to affirm the decision of the trial court. The trial court held a full 3-day evidentiary hearing on these issues. And the judgment is extensive. It includes extensive specific findings on all of the issues that Mr. Byrd has raised.
Can we go to the liens that were disposed of on summary judgment briefly? So the climate controlled and the oral agreement. In your view, did the trial court have any other justification on summary judgment for finding that those liens were fraudulent other than the amount of the overstatement?
Absolutely, Your Honor.
And why is that?
It's extensive.
At the summary judgment stage, particularly.
At the summary judgment stage. It's important that this case went on for years. This case started in 2010. August 20th, 2010 was the date of the blow-up. And the history of this case was such that by summary judgment, and we were headed towards a bench trial, by summary judgment, there was really no additional fact to develop. All of the witnesses, including Mr. Kinberg, had been deposed, and so had Mr. Cherry. And all of the invoices that were ultimately relied on were on the record, as was every other document that is ultimately in the record. There's nothing new at trial. And specifically, going to what we've been calling liens 4 and 5, because they match up with counts 4 and 5 on the contract claim. But specifically on liens 4 and 5. Okay. Lien 4 is essentially based on duplicate invoices. And if I can go to the history just a little bit, because it's based on the history of the plaintiff, or Cherry's, the appellant's, own statements concerning this specific lien at different times. Every time he's asked to explain it, we get a different answer. And
so in the sense that, summary judgment standards, whether there's this disputed issue of material fact.
But it's not a disputed issue of material fact, and this is what I'm going to. Okay. Because at summary judgment, we accepted his final answer. After summary judgment, after trial, the judge ultimately determined that it ought to be reduced even further. But here's what happens. What happens is he files a lien, and it's for a certain amount, and that's in 2010. Mr. Kinberg asks him to double-check his work. He doesn't do it. He goes to another attorney. They file a claim. Nothing changes. There's a statement as to the contract value and what's due and owing. He answers interrogatories in 2013. Again, no changes. Everything that was claimed is been done and completed and is due and owing. He's deposed in 2015. Again, no changes. Everything he claims, everything that was claimed was done, completed, and it was due and owing. And then suddenly, after a motion to compel, because what's happening on our end, Your Honor, at this time, is we're asking ourselves, the question that we asked ourselves over and over again is, what is he saying? What is he saying? Because his explanations as to how this came about, how it's all due and owing, they change. They just change. So there's a motion to compel, and that motion to compel results in those second interrogatories. And the result in Cherry finally saying, oh, oops, this claim was actually, I filed a lien for $4,245. Oops, sorry. It was actually supposed to be $3,195.
And wasn't at that point the evidence that, one, there was an affidavit that he had provided all documents to his attorney, and then two, wasn't at summary judgment stage, the deposition of Mr. Kinberg with a statement basically that he would not have filed the liens for that amount if he did not have all the information. Wasn't that evidence before the court at the summary judgment stage?
Sure, absolutely, it was.
And so how does that not create a disputed issue of material fact? If those factual findings were made by the court, obviously they were rejected at the final judgment stage, but if they were accepted by the trial court at the summary judgment stage, wouldn't that remove it from, gross or willful negligence?
No, absolutely not, Your Honor.
Why not?
And I'll give Cherry credit that he gave, we'll take that statement as true for purposes of argument. He gave everything to his attorney. He gave to his attorney invoices, 89, 90, 91, 106, and 107. And when you add those invoices up, they add up to way more than the claim. He gave all of those documents to his attorney. The judge determines, well, let's go back to what Cherry first says. In 2013, he says it's based on invoices 106 and 107 only. In 2016, he says it's based on invoices 89, 90, and 91. But the lien itself is based on all five. And after trial, the judge holds that it can't be. She specifically discusses invoice 107 in her final order.
Isn't the point, isn't that after trial and after evidence has been weighed? And so I'm struggling to see how that is not an issue that's disputed, a material fact that's disputed at the time of summary judgment.
Well, the material fact that's disputed is that Cherry gave 5 invoices to Mr. Kinberg. Mr. Kinberg added them up correctly. There's no calculation error there. It's not a minor error, it's not a calculation error, and it can't be said to have been a good faith dispute as to the amount due, because that requires a dispute. The cases concerning a good faith dispute as to the amount due and discussing reliance on the advice of counsel, they don't talk about a contractor who brings wrong invoices. The attorney doesn't advise as to whether the contractor has done the work or hasn't done the work. the attorney advises as to what might be includable. For example, gator boring. We've heard a lot about gator boring in this case, and it's a case that's been going through the second DCA, slightly ahead of us. It was a changed conditions claim. So there's a valid underlying dispute in terms of interpreting the contract.
So
This isn't a dispute, this is just a contractor. He says he's entitled to be paid twice for the same work.
So is it your position that at the summary judgment stage, it was essentially undisputed that Cherry knew the documents that were provided to his attorney were inaccurate?
Cherry doesn't need to know that they were inaccurate. Cherry's charged with checking his own work. Cherry's charged with a standard of care. The standard in the statute is negligence, gross negligence. Cherry's not allowed to, and he's not excused from billing twice for the same thing. He's not excused from that. And at the very least, he's a professional, and he owes a professional standard of care to his client, my client. And he didn't provide it. He didn't check his work, even after he was asked to do so.
Did he lien for work that was not done?
Absolutely. Whether you want to call it billing twice for the same work, or leaning for work that was not done, he absolutely did, yes.
You know, as a professional, he goes to another professional, his attorney, and says, I'm an electrician, you're a lawyer, these are legal things, handle it. Why isn't he allowed to rely on his lawyer to handle things for him in terms of calculating and filing the liens?
Mr. Kinberg testified that he didn't have anything to do with checking the work. He wouldn't have any way to know what Cherry had done or hadn't done unless his client told him. Mr. Cherry handed Mr. Kinberg a pile of invoices. The invoices were wrong. They included extensive, what Cherry says are errors. We think it's worse. The judge implies that she tends to think it might be worse too. But even if they were errors, they were extensive. They are far beyond minor miscalculations. They are far beyond the sorts of errors that would be excused. And going to lien number, what we call lien number 5, that lien changes also, incredibly, Your Honors. At the time when Cherry answers the first interrogatories in 2013, that lien is based on a certain set of invoices, and they add up to the amount due. Let me take that back. And in 2016, when he answers those interrogatories, it's a completely new set of invoices. Some of them just drop out. They evaporate from his claims altogether. We don't know to this day where they've gone. And he doesn't have any explanation for it whatsoever.
So we know that the liens were overstated, right? That's obvious. But we know that the statute requires more than just the liens being overstated in order for a lien to be fraudulent. So what would you point to, both in the summary judgment order and in the final order, that shows that the trial court made that determination that there was something more than an overstatement?
I'm glad you asked that question. Thank you, Your Honor. Oh, but if I can just back up one other second. There's also evidence that Cherry not only didn't check his work, but that later on, he actually affirmatively hid the information. In 2016, there's those second interrogatory responses pursuant to motion to compel, but they attach a privilege log. And that privilege log references a spreadsheet showing all of Cherry's transactions, created in April of 2016. So in April 2016, he had that information. He knew about the mistakes. He knew that claim 2, that lien number 2, had been fully paid. He knew all the mistakes, but he hid them. He didn't say, hey, you know, you're my client and I wanna do the right thing, I wanna fix this. No, he objected to the second interrogatories. We had to file a motion to compel, And then he objected, right? There was hotly disputed. And finally, then we get these second interrogatories, reducing everything practically across the board, dropping claim 2. And then, after that, we finally get a supplement. And the mysterious invoice 71, which shows the payments on count 2, finally appears for the very first time. It was never, ever provided before September of 2016. I think all of those facts tend to show a maliciousness. But let's go to the trial court's order. Ooh, I got 6 minutes. Yeah, I can say a lot in 6 minutes. Okay. Bear with me, please. Okay. The trial court order makes numerous references to credibility. The trial court order at paragraph 8. At paragraph 8 says, credibility. At paragraph 8, Tomahawk's construction manager is more credible than Cherry. At paragraph 14, it says, it discusses the famous invoice 71 and discusses how there are actually 2 payments on that invoice that show that this lien had been overpaid in advance and that Cherry had never actually given even credit for the overpayment. They tried to get us to pay again. At paragraph 31, this clearly shows that Cherry Bomb's invoice 107 was a mistake, at the very least that Cherry Bomb kept poor records, and at worst, that this invoice was manufactured in anticipation of recording liens and filing this lawsuit. Mr. Bird would like you to think that that means she stopped short. I think she's gone beyond the standard. The standard says gross negligence. The records are absolutely, if you take a look at the totality of the decision and the totality of the many, many discrepancies, absolutely beyond what ought to be excused, far into gross negligence, and possibly, according to this judge, intentionally manufactured in anticipation of filing this lien.
How about for the summary judgment?
Your Honor, I'm sorry?
How about for the summary judgment, though, in terms of any specific findings of willfulness?
Yeah, at summary judgment, there's, on the record, Tiffany Walters, who was with Mr. Bird's firm, asked for a clarification as to what the judge was holding, as to whether she was holding that it was willful or intentional. And the judge said that specifically, no, that was not the standard required of the statute, but that it was gross negligence, and that she was holding that they were grossly negligent, specifically in light of the fact, or especially in light of the fact, that Mr. Kinberg had asked him to check his work.
Basically says that the articulation of the reasoning on summary judgment says that, lien H or Exhibit H, lien I or Exhibit I was overstated significantly, so I'm going to grant summary judgment on those, and then, as it pertains to the other ones, it's an insignificant difference, so I'm going to deny summary judgment on those. How is that not an indication that the trial court was basically granting summary judgment based only on the amount of the overstatement and not based on specific findings of gross negligence or
Well, she says that it's gross negligence, Your Honor. But even more than that, the evidence was all in front of the court. There was an hour-long hearing. and the judge was entitled to make that determination.
On summary judgment.
On summary judgment, absolutely. And I want to point out another fact. If we're talking about error, right, the error has to be reversible. He needs to show not only that there was an error, but that there's a likelihood of a difference if it goes back. And that's not the case here.
De novo would just be whether it's a legal error.
Right.
Correct, yeah. That's whether it's reversible.
No, Your Honor. There needs to be a likelihood that it's going to affect the outcome. You can say there's an error, but if it doesn't affect the outcome, it's just a waste of proceedings. And I'll tell you, it won't. And I'll tell you why. Because the summary judgment was directed only to Tomahawk's defense, the fraudulent lien defense. It wasn't directed to Tomahawk's fraudulent lien counterclaim. There was no evidence whatsoever that Cherry was prevented from presenting at trial. He was absolutely allowed to ask every question. Mr. Kinberg testified, Cherry testified, and the court made specific findings on liens 4 and 5 concerning the amount of the overstatement. And after trial, see, at summary judgment, we accept as true Cherry's final statement. We just give him full credit for it. There you go. Okay, you said it was, you said it was 53 and 5. It was 53, 51 first. You changed it to 26. Okay, we'll give you credit for that. But after trial, the court determined that the correct amount would have been half of that again. So ultimately, it was overstated, not doubled, but quadrupled. And the same with count 4. After trial, it started as a contract for $4,910, a lien for $2,445, and after
The red light, so.
well, anyway,
Judge Sasso, do you need anything
it was
further? Okay.
reduced again by another 25%.
All right, thank you.
I'd like to address a little bit the issue of prejudice to Cherry Bomb, and there's two that I think require reversal. The first is the fact that the only element of fraudulent lien that the trial court considered at both summary judgment and at trial was the amount of the overstatement is hyper prejudicial because nearly every other factor in the analysis militates in favor of Cherry Bomb. Advice of counsel should have been considered as part of that analysis. Mr. Kinberg isn't even mentioned in the final judgment, and the trial court, in my opinion, misconstrued the letter from Mr. Kinberg after the fact at summary judgment. Nevertheless, summary judgment was, as Your Honor has suggested, based solely on overstatement, as was the final judgment. Mr. Cherry did not include amounts in his claims of lien for work that he did not do. And it's important that the burden of establishing a fraudulent lien falls on Tomahawk. It's their job, their burden, as either a defense to my lien foreclosure claim or for their counterclaim for fraudulent lien to demonstrate, from an evidentiary standpoint, the existence of a fraudulent lien. And they didn't do it. And even if they had, the trial court did not consider all of the factors that it is required to consider when making that determination. Had it done so, the result would have been different. Secondly, what we are left with is an inconsistent result. The testimony, undisputed, was that Mr. Cherry, with Mr. Kinberg, calculated all of his 5 claims of lien in precisely the same method each time. He provided the invoices for payment and the invoices for the work done to Mr. Kinberg. He did the best he could to work with Mr. Kinberg, and he relied on Mr. Kinberg. At summary judgment, 2 of the liens, based on amount of overstatement, are found to be compiled grossly negligently, which is an indictment of the method by which they were prepared. At trial, 2 additional liens were found to be overstated. No comment really as to method, although the implication is that the method was wrong, and yet the parking area contract was found to have been calculated correctly, using exactly the same method. So you have an inconsistency between the summary judgment and even inherently in the final judgment because the same method is used. The cases that we've cited in our brief, and even, again, cited by Appellee, there's more than just an overstatement. There requires to be much more. If you look, both sides were confused about payments. The history of the facts show that 70 invoices were done on an as-needed basis. Mr. Cherry would invoice Tomahawk for work after a week or 2 weeks, and they'd pay with one check. In fact, on August 20th, they had a check for $11,300 for work that Mr. Cherry had performed. They argued over 3 outlets and 1 halide pole, and they didn't pay him $11,300, including $2,000 that everyone agrees
The
was
evidence
due.
show he didn't ask for partial payment?
He's not, Your Honor, he did not ask for partial payment. But the onus in the contract for payment of at least the $2,000 down payment was on Tomahawk. And the undisputed evidence was they didn't offer him partial payment after the fact. His contract says, I can stop work if I don't get any timely payment. That's exactly what he did. 2 days, 3 days later, they send a letter with their attorney, or perhaps it was a week. That's Exhibit 18, which shouldn't have been admitted in the first place as the business record exception wasn't properly laid. Hearsay was never overcome. And they say, well, we owe you $8,300. A week later, they owed him $11,300. They had a physical check in their hand for that number. No explanation of the reduction for $3,800. Neither side kept good records in this case. They should have. Mr. Cherry did the best he could. He had a bookkeeper that was experienced in keeping records, and he went to an attorney because he knew what he didn't know. And Mr. Kinberg stood by his calculations even as of August of 2018. Did Tomahawk ever ask for clarification? No. 2016, we give them our answers to second interrogatories. Did they ask us anything about our calculations that we set out in there? No. 2 years later, there's a trial. Now they're complaining about what we said. The calculations were in good faith. They were miscalculations. We corrected them. The evidence showed at trial we were owed $17,000.
All right, thank you.
Thank you, Your Honor.
And we'll be in a 5-minute recess, and we'll come back and take the third case.